Welcome to jury charge and literary practice. We'll start out with this jury charge. Ready? Here we go. Actually, you know what? Let me just quickly review some of the words in here so you can maybe practice them a little bit before we get started. We have Commonwealth of Pennsylvania. And sympathy, prejudice, all right. Again, Commonwealth. They refer to the Commonwealth, which would be a capital C on Commonwealth, and then Commonwealth of Pennsylvania. All right, here we go. Ready? You have been selected and sworn to determine the facts and render a verdict in the case of the Commonwealth of Pennsylvania versus Robert Greene, who is charged with 1 count of robbery, 1 count of aggravated assault, and 1 count of firearms not to be carried without a license. As I told you at the beginning, I will now instruct you as to the law you must apply to this case. The law applicable to this case is contained in these instructions, and it is your duty to follow these instructions. You should consider these instructions as a whole. You may not pick out one instruction and disregard others. I caution you not to allow sympathy, prejudice, or any emotion to influence you. It is your duty to base your decision strictly on the evidence. The evidence which you are to consider in reaching your decision consists of the testimony of the witnesses which you heard, and the exhibits which you saw introduced. You must consider all of the testimony of the witnesses and the exhibits, but you must not consider any testimony or exhibits to which I have sustained an objection or which I have ordered stricken from the record. You are here for one purpose, and that is to discover the truth and apply the law to the truth as you discover it. A fundamental principle of our criminal justice system is that a person accused of a crime, the defendant, is presumed to be innocent. The mere fact that the defendant was arrested and accused of a crime is not any evidence against the defendant. In addition, there is no inference of guilt created by the fact that there was a complaint filed or even that there was a trial. Furthermore, the defendant is presumed to be innocent throughout the trial unless and until you conclude, based on careful and impartial consideration of the evidence, that the Commonwealth has proved the defendant guilty beyond a reasonable doubt. It is not the defendant's burden to prove that the defendant is not guilty. Instead, it is the Commonwealth that always has the burden of proving each and every element of the crimes charged beyond a reasonable doubt. A person accused of a crime is not required to present evidence or prove anything in his or her own defense. If the Commonwealth fails to meet the burden, then your verdict must be not guilty. On the other hand, if the Commonwealth does prove beyond a reasonable doubt that the defendant is guilty, then your verdict should be guilty. Although the Commonwealth has the burden of proving the defendant guilty beyond a reasonable doubt, this does not mean that the Commonwealth must prove its case beyond all doubt or to a mathematical certainty, nor must it demonstrate the complete impossibility of innocence. Okay, we'll stop there. So they said Commonwealth a lot, right? And we had, I didn't see this, we had mathematical certainty. Mathematical certainty. All right, so we will finish that one up later. Now this is literary material, and it's to help you with your pronouns, okay? And it kind of explains what it's doing, what the purpose of it is as you're writing. So we'll just get right into it. Okay, ready? Here we go. In writing on this machine, I sometimes shadow when I attempt to write pronouns, such as I, you, and he, and I sometimes misstroke when I write the words this, that, and when, what, who, were, and where, which, there, it is, it's, what is, and what's. When I read these notes after writing this material at a push speed, I often find I have you for he, or he for I, or I when whom that transcript was speaking of was he or you. Sometimes at these push speeds I find when I was sure I hit that, it turns out that that is this. Sometimes my this is that, or even an occasional there. It's easy to stroke it is instead of it's. However, again, when you or I push, we may write it is for it's, and it's for it is. It is not quite as easy to confuse it has for the word it's, or it's for the words it has. What, when, who, and which are just a shadow away from each other, so it's easy when what you hear is what to have when or who in the notes, or when what I hear is a who to have a what or when in my notes, or when what he hears is a when to have a who or what in his notes. That was just part of it, but it gives you a little bit of an idea that, again, we're focusing on those little words that sometimes you might misstroke. So it's just good practice. So we will finish that one up another time. And let's start a different jury charge for some more jury charge practice. And this is regarding an accident. Let's see if there are any words in here. I don't see any right off the bat, so we'll go ahead. Sufficient. I don't see any words that I believe would be too challenging, so we'll go ahead and get started on this one. Okay, ready? The defendant's attorney has indicated that the accident occurred resulting in the death of an individual, but that the defendant was not guilty of committing a crime in this regard. Portions of testimony from depositions have been admitted in evidence in this case. In these depositions, you will see that both sides have different opinions as to what happened. If you need to have any of these portions of this evidence read to you, please let the bailiff know. I will be in my chambers. He will advise me of your request. You must keep in mind that we are here who was involved and injured in this accident that resulted in the death of another. Whenever reference is made in these instructions to plaintiff or defendant, such reference is related to each party in that capacity. The plaintiff's case in this action is put forth by the district attorney on behalf of the people. It is the duty of the plaintiff's attorney to prove the case. The district attorney has indicated to you that he has direct evidence to prove the case. It is now up to you to decide if the district attorney has been able to prove the case under these circumstances. If you are not able to decide beyond a reasonable doubt that the defendant's condition caused the accident, you must rule in favor of the defendant and set him free. The district attorney has brought forth this action because it was determined that a criminal act may have occurred. The burden of proof is on the district attorney to prove that the defendant caused the death of the individual on purpose. You must consider the element of intent. The cause of action or the reason for the suit is the accident in question. You must determine whether the direct evidence in this case corroborated the view of the district attorney. You have been presented with direct and circumstantial evidence by both sides. Now you must determine which side has more credibility. As stated, the law makes no distinction between direct and criminal evidence as to the degree of proof required. All right, now I have some literary practice from one of the magazines from NCRA, the Journal of Court Reporting. And this article is called Wellness 101. It says, make your entire body top priority. So it really just talks about exercises, just things you can do to make yourself more comfortable when you're sitting and writing on your machine. Okay, ready? Here we go. Everyone knows you wouldn't be able to perform your job without those flexible fingers moving at the speed of speech. But that doesn't mean your hands should be the center of attention. When it comes to overall reporter well-being, you need to make your entire body and mind a top priority. There are activities and ways to support your back, minimize stress, and keep your memory sharp for those long days on the job. Choose the right chair. It's a fact. Court reporters, cart providers, and captioners sit for long periods of time. When there are so few breaks, your back may be the first to feel pain. The National Institutes of Health cites back pain as one of the most common medical problems affecting 8 out of 10 people at some point. Setting up the right seat from the start could help. Arrive early and spend a few minutes finding a chair that's easily adjustable. The best height is when your feet are flat on the floor and your knees are equal to or slightly lower than your hips. If a good chair isn't currently in the room, ask for what you need. I'm not afraid to ask. Sometimes demand a better chair to sit in, says Lori Judd, RMR from Las Vegas. She makes it a priority. Judd adds that if none exists, she'll grab the Backjoy from her car. According to the company's website, Backjoy supports posture, relieves pressures that cause back pain, and makes sitting more comfortable. Stretch to prevent stiffness. When you get that well-deserved break, take advantage of it. Get up from your chair. Rest those hands and stretch your neck and shoulders. Kimmel McDermott, RPR from Pittsboro, North Carolina, who does yoga regularly, has great tools to loosen her body quickly and gently. Since doing yoga, she has noticed it combats the stiffness from sitting in the courtroom. My yoga teacher taught me and other court reporters inconspicuous stretches we can do in a 30 to 45 second pause in proceedings while attorneys are consulting or meeting at the bench. McDermott says the stretches usually actually keep her from getting stiff in the first place. If you're not comfortable doing stretches in the courtroom, do them before entering or while having breaks during the day. Judd even goes to the ladies' room to do a yoga move called downward dog. I know that stretches my spine where it gets stiff during depots. All right, that'll get us started on some wellness things. And I would say, even this all would apply while you're in school as well. All right, so we'll get back to that article. And now let's carry on with one of these jury charges that we started a little earlier. I'm sorry. Okay, here we go. Back to the one regarding the Commonwealth of Pennsylvania. Ready? A reasonable doubt is one that would cause a reasonably prudent person to pause or hesitate before acting in a matter of importance in his or her life. A reasonable doubt must fairly arise out of the evidence that was presented or out of the lack of evidence presented with respect to some element of the crime charged. A reasonable doubt must be a real doubt. It may not be an imagined one, nor may it be a doubt manufactured merely to avoid carrying out an unpleasant duty. To summarize, ladies and gentlemen of the jury, you may not find the defendant guilty based on the mere suspicion of guilt. The Commonwealth has the burden of proving the defendant guilty beyond a reasonable doubt. If it meets that burden, the defendant is no longer presumed to be innocent, and you should find him guilty. On the other hand, if the Commonwealth does not meet its burden, then you must find the defendant not guilty. The law requires that I repeat that the arguments of counsel are not evidence and should not be considered as such. However, in deciding the case, you should carefully consider the evidence in light of the various reasons and arguments which each lawyer presents. It is the right and responsibility of each lawyer to discuss the evidence in a manner which is most favorable to the side he represents. All right, and that will conclude our literary and jury charge practice. Thank you.